So a few more notes on the Sin case. Um, so we have a relatively short period of time between presentation of the prenuptial agreement and the wedding. And we have both parties represented. That's great. And we have somewhat of a list of financial asset disclosures. I think that's a big problem in this case. This is a little bit of why it went south. If you look at his disclosure, top of page 267, it's showing assets of about 853,000, but we have other evidence um, related to his life insurance. Sometimes when you get life insurance, you have to prove that you have a net worth to justify getting a certain amount of life insurance on your life. In other words, why would a life insurance company insure your life for millions if you're not worth millions? So in this case, there was some outside evidence that he had gotten some life insurance and represented to the insurance company that he was worth about 6 million. So that's a pretty big difference: 853,000 in one case, 6 million in another. Um, so his financial disclosure was pretty inadequate. It was he wasn't he wanted to keep some things secret and wasn't telling her about it. You got the lawyers kind of interacting with each other, trying to get some changes made. You've got Edward saying, "No, I'm not going to do it. Sign this, and this is all it's going to be." That in and of itself, while rude and not nice and not kind of the conversation you'd expect between two people who are about to express their love for each other, um, is is not is not what made the prenup invalid. Him saying, him being rude is not what makes it invalid. In this case, the hard facts for Edward are the fact his disclosure is pretty inadequate. He's not giving her enough for her to fairly assess the facts and fairly waive what she was going to waive. If he had, she may have still waived it. She may have still decided, I want to get married, and he says, I got to get married, so I got to sign this agreement. But his downfall was that he just did not do a fair and adequate disclosure for her to waive those rights with kind of eyes wide open of what she was giving up. Um, so it's a good example of how not to proceed. So we've barring a prenuptial agreement where the parties clearly waive things like elective share, omitted share, alimony, rights that they owe to each other. Barring that, we've got some protections in the law for an unintentional disinheritance of a spouse, and that is where you you have a will and you've got it in place and it works fine, and then you get married. So now, and then you die before you change your will after your marriage. So we're kind of left to wonder, did you mean to leave out your spouse, or was that unintentional? And is your spouse entitled to something because she wasn't listed in your will? And that conversation starts on page 271. That's what we call a pretermitted or an omitted spouse. Um, that's very different from an elective share. An elective share is somebody who was intentionally left out. You knew you were married, you left them nothing. A pretermitted or omitted spouse is someone that um, we don't have any way to know, did you mean to leave this person out, because your will already existed before you got married. And those recovery as an elective share and recovery as an omitted spouse, are sometimes different amounts because they're different statutes. The elective share statute has its mechanism of how you come up with the elective share and how you satisfy the elective share. The omitted spouse provisions have a statutory scheme, how you come up with that amount and how you satisfy that amount. Um, so you can be entitled to both. I mean, if you're a spouse that's not included in a will, then you really and you were married after the will was prepared, then you can decide, do I want my recovery to come from an omitted spouse statute or an elective share statute? Um, and on its surface, the omitted spouse provision sometimes looks bigger, because it's typically what, if you're an omitted spouse, your recovery is typically what you would get under the intestacy statutes as a spouse. And some of those statutes say 50%. Some of them say all, if it's no kids and no other heirs, and depending on what the statute in your state says, whereas the elective share statute is typically somewhere in the 1/3 range. Um, but the omitted spouse on its face looks like it could be a bigger amount. But you have to read the statutes very carefully in your state, because most times they only apply to the probate assets. So sometimes that can shrink down an omitted share recovery pretty significantly if there's not a lot of probate assets. Um, so the purpose of the omitted spouse statute is to protect a spouse that was unintentionally omitted. Kind of, in your notes, underline the word unintentionally. What if you have what if we have evidence that this was not unintentional? If there's certain evidence, then the omitted spouse statute won't apply. Bottom of page 271. There's three exceptions to the surviving spouse's entitlement. One, if it appears from the will or other evidence that the will was made in contemplation of the marriage. So the testator goes and gets the will done knowing he or she is about to get married, and makes reference in the will that I'm about to get married and I realize I'm not leaving anything to this person, and that is not an accident. That is intentional. Um, Number two, the will expresses the intention that it's to be effective notwithstanding any subsequent marriage. So similar statement. You just make it clear that I'm not providing for my spouse who I'm not married to yet, but I'm going to get married to shortly, but I'm intentionally leaving little or nothing to him or her. Or three, the testator provided for the spouse by transfer outside the will, and the intent that the transfer be in lieu of testamentary provisions is shown by the testator's statements or reasonably inferred by the amount of the transfer. So it's not that your surviving spouse got nothing. They just happened to get it through life insurance, retirement assets, joint right of survivorship property. They got it other ways. And you either make it clear that's what I wanted him or her to get, not stuff from my probate estate, or because the amount is so big in relation to the probate estate that intent can be inferred. Always better to state it clearly than leave it up for somebody to infer it. So bottom of page 271 gives you the three exceptions to that. Also, a big thing to watch out for towards the bottom of 271, you've got the quoted statute, you've got the paragraph that starts moreover, and then you've got the one paragraph above that starts under the UPC. Middle of that paragraph, it says the surviving spouse's portion is limited to a share of the property that is not devised to the testator's children born prior to the current marriage. So if the will leaves everything to the testator's kids that are born before the marriage, then there's no part of the probate estate available to satisfy the elective share. Some state statutes just say that. I think there's a typo in here. Going back to that section, it says the surviving spouse's portion is limited to a share in property that is not devised to the testator's children born prior to the current marriage, and who are not a child or adolescent of the surviving spouse. So what you're really looking for is if somebody's making an omitted spouse claim, is there any probate estate available that's not going to the testator's children that were born before the marriage? If there's not, I mean, if it's all going to testator's children born before the marriage, there is no probate estate available to satisfy the omitted spouse share. But you have to look at your state statute to see if you have that exception in it. An example of application of that provision is top of page 272. We've got Grant is married to Zandra. The second paragraph says assume that Grant's premarital will devised all of his estate to my three children, Alex, Beta, and Chandini in equal shares, and that A, B, and C are children of Grant's first marriage, which ended in divorce. Several years later, Grant married Zandra. He never updated his will. He dies, and he's survived by A, B, and C, and by his spouse Zandra. Zandra is going to, it's natural for her to pursue the omitted spouse route to see if she has any recovery. But her right under the omitted spouse statute is to take an intestate share, which could be a big percentage, an intestate share only in that portion of his estate not left to his children born prior to the marriage. So in that example, his wife gets nothing because all of his estate is left to children born prior to the marriage. So that's really why you have to run both of these allowances to see which one gets you more. Even though on its face one may look like it's a bigger share. So that's our spouse. Our spouse has a couple rights that's got to be pursued: the elective share, and the omitted share, the omitted spouse share. What do we do with children? Children that either are intentionally or accidentally omitted. I told you in the beginning of the class, you can always disinherit your kids. It's pretty easy to disinherit your kids. Louisiana is one exception where sometimes you can't disinherit a kid. Um, the other, I guess, exception to that is a kid that's born after you do your will. And so it's kind of like a spouse. We don't know if you meant to. We don't know if you meant to disinherit that kid because he wasn't around at the time you did your will. So we have to make some assumptions. We have to assume maybe you didn't mean to disinherit him, unless you make it really clear that your goal was to leave out your children you have now, as well as future born children, future born or adopted children. And even then, I don't know that that's foolproof that you can disinherit future kids. It's best if you the best approach is you come back later after they're born and restate it again that you wanted them to be omitted. Um, you know, but can you intentionally inherit future children? Probably, but I think you do it with a little bit of risk that somebody's going to question whether it was intentional or not. Um, but let's assume you did not make it clear in your will that you wanted to disinherit future kids, because that would be a little bit peculiar. But let's make it clear you didn't say that. So you did disinherit your current kids, let's say, but you didn't disinherit future kids clearly in your will. So now we're kind of back in statute world. What does the statute say to that? I'm going to come back to the case in a minute. The case is pretty interesting. The UPC approach says that failure to mention children born or adopted after the execution of the will is unintentional and allows the children to inherit a share of the estate as if the decedent died intestate. So you have to see what would the child have received as an intestate share, kind of like an omitted spouse share, and that's what they could possibly get. Under the UPC approach, you also have to look at one other thing. Um, did the estate pass substantially all of the estate pass to the other parent of the child that's disinherited? And so let's add some gender to all this. So if you have a deceased father with a child born after the time the will was prepared, um, we potentially have an omitted child who potentially can receive an omitted child share because they were born after the date of the will, unless substantially all of that father's assets are left to the other parent of the child, to the mother. If they left substantially all the assets to the mother, the the omitted child does not take. And I suppose it's for a couple of theories. One is that the mother is going to take care of it, so it's just going to flow through the mother and then eventually down to the child. Um, and the mother's going to use the assets to care for the child. You're not. There's a second chance to inherit through somebody who's um, whose love for the child and loyalty for the child is kind of the same as the deceased father in my example. so we don't have to give an omitted share in that approach. That's the UPC approach. Um, and another kind of thing to watch for is you have to really read the statute to see, does the right to take as an omitted child, does it stop at the child's level, or does it pass down to descendants of the child under like a per stirpes or take by representation approach? So if somebody prepares a will, leaves out later has a child, so we have an omitted child, and then that child dies but has kids, do those kids, so I guess grandkids, do those grandkids get to take through the rights of the omitted child who was their parent? And you just have to watch your statute. Most of them only refer to the child that's omitted. They're not trying to pass it on down to descendants of the child. So just make sure you look at your state, or the state that's um, applicable to the fact situation, to see if it stops at the child or goes on down. Bottom of page 277, they tell you how the omitted child's share is satisfied. So once you determine if you've got an omitted child, two, do any of the exceptions apply? No. Three, the child takes an intestate share. How do you fill up that bucket? How do you fill up their intestate share? Um, Bottom of page 277. G executed her will. She had two living children, A and B, and her will devised $7,500 to each of them. She then had another child, C. C's intestate share is one third. Three kids of the decedent, and intestacy says they all get one third. How do we fill up C's one third? How do we pull money to get C to the one third piece? C is entitled to $5,000 because the reason we know that is she was leaving 7,500 to each of her other two kids. 75 and 75 is 15. So the total amount that's going to be available for the kids is 15,000. C is entitled to one third of that 15 because he's one of three kids, which is 5,000. How do we get the five to him? $2,500 is going to come from A's $7,500 devise, reducing it to five. And $2,500 is, I think I said that first. 2,500 comes from A's 75, reducing A to five. $2,500 is going to come from B's $7,500 devise, thereby reducing B's devise to 5,000. And then C now gets 5,000. He's getting two $2,500 pieces that add up to five. So logistically, that's how it works. They walk you through another example at the top of page 278. You can read through it, and you should, and you probably have, to show you how you pull from the different people to get to the amount that's going to the omitted child. All right, I want to go back to the real quick, page 278. They give you just a kind of a snippet. The New Hampshire approach um, is just clarifying that every child born after the decease of the testator and every child or issue of a child of the deceased not named or referenced into the will is entitled to a portion. It kind of shows um, that we're going deeper than the child. While the UPC only protects the omitted child, New Hampshire's approach protects the child and descendants of the child if the child is also deceased. It doesn't mean they all get something. The descendants of the children only take under an omitted child arrangement if the child is also deceased, so where they're moving up into his position. But your book says that approach is kind of dwindling. I don't know the stats on that, but the point is you need to check: is it stop at my child, or can descendants of the child take? All right, now I want to go back to the Gray case. If you read it, which I hope you did, two things: it's Alabama. It's not that old, 2006, and it's actually kind of interesting. You have John, who was married to Mary Rose Gray, and he had two children from a prior marriage, Robert and Monica. His will devised all of his estate to his wife Mary, So he marries Mary and then does a will that leaves all of his estate to Mary, and he did not include his two children from the prior marriage. In 1984, 3 years after the will, he and Mary, his second wife, had a baby named Jack. And then in 1989, John and Mary divorced. So, um, in and through all this, the will is dated 81, and he's already married to Mary, um, Jack's mom. So it seems, pretty normal situation. Guy remarries. He's loves his wife, devoted to her. He executes a will that leaves everything to her, leaves out his kids from his prior marriage. Not sure, what caused that or what the rationale was behind that, but left all his assets to his wife, who then he has a baby with. Um, but then divorces the wife. So then he dies, and the executor of his estate, which I think was his brother, petitions the Jefferson County Probate Court to probate the will. He has not updated his will to reflect the fact that he's divorced now from Mary. So we don't have any clear direction on, hey, what would you do with your stuff if you weren't married to Mary anymore? You have three kids, two from a prior marriage, one from your marriage with Mary. What would you do with your stuff? Because you don't have a spouse anymore. Um, and separately, as you know, we have a statute that removes the spouse when you get divorced. It removes the spouse from um, the the flow of assets from the will. She's not going to take anything because they're divorced now. But he hasn't mentioned his younger kid Jack. And so does Jack get to take? Because Jack wasn't in the original will. The will was already in place before Jack was deceased, so of course it didn't mention him. Does he get to take anything? And you kind of would think yes. I mean, especially if a mom's not taking it, you would think why wouldn't it go to Jack? Maybe some to his older siblings too. Um, so Jack petitions the probate court for an order finding that he's entitled to a share of John's estate under one of the Alabama probate code sections, the one for omitted children, which says if a testator fails to provide in his will for any of his children born or adopted after the execution of his will, the omitted child receives a share in the estate equal in value to what he would have received if the testator had died intestate. So roughly, if there's three kids, roughly he gets one third. But just like the UPC, the omitted child statute does not apply, if one of these three things is in place. It does not apply if it appears from the will the omission was intentional. Two, when the will was executed, the testator had one or more children, and which he did, and devised substantially all of his estate to the other parent of the omitted child. Um, We'll come back to that. Or three, the testator provided for the child by transfer outside of the will, and the intent of the transfer be in lieu of the testamentary provision can be reasonably proven. Well, we know three isn't the case because he didn't leave anything to Jack outside of the will. Number one is not the case because it's not clear from the will that the omission of Jack was intentional. There's nothing in there that says I hereby omit future kids because remember, Jack wasn't alive when he prepared the will. But two says you don't get an omitted child share if the will was executed and the testator had one or more children, which he did, and devised substantially all of his estate to the other parent of the omitted child, which he did. At the time the will was done, 1981, he had one or more children from his prior marriage, and his will left all of his estate to his wife, Mary, who he was married to. Um, and remember, kind of the theory behind that is, well, if you leave all of your stuff to the other parent of the omitted child, isn't the omitted child just going to get it later after the parent of the other parent, the mother in this case of Jack, is done with the assets? Probably. So our fear of omitting the child forever is kind of gone because it's just going to flow through his mom and go on down. But when you divorce, Mary's no longer taking it to then leave it to Jack, because a separate statute pulls Mary out of the will. Um, and so surely that's not still an exception to the omitted child statute. So the trial court said that. They're like, no. Um, the trial court said Jack's entitled to a distribution from the estate, entitled to what he would have received if the father had died intestate. The family appeals. Presumably, the family is the two older children from the first marriage. Because remember, I mean, we have a will, but the will leaves stuff to Mary, and that's not going to happen because they're divorced. So it's probably leaving things to the other two kids as contingent beneficiaries. The will probably said something like, "I leave my estate to Mary, my wife. If my wife's not living, then it goes to my kids, who were the existing kids from the prior marriage at the time the will was done." So they bring an appeal to the lower court saying that Jack gets one third, and they say, you almost have to say it like this. It's almost like they're saying, "Hey, we realize this is rough, and we realize that um, it's kind of mean, and um, it's bad for Jack. But if you read the statute, the omitted child share does not apply if, top of page 274, when the will was executed, the testator had one or more two children, check, he did, and the will devised substantially all of his estate to the other parent of the omitted child, check." You can check both of those elements of that exception, and the exception is like literally applies because the facts show that exception applies. Um, and the appellate court was kind of like, yeah, it does. A literal reading of the statute in this case is the testator had one or more children alive, and his will at the time he executed it, which is the time the statute says to look at, he left all of his assets to the other parent of the omitted child. You know, and they kind of just stop there. Period. They don't look at, oh, and by the way, who he divorced and who is not going to get anything. Therefore, nothing is going to flow through the mother down to Jack. Um, Kind of um, a rough result for Jack, but it's the result the statute gets you. The remedy there is get the statute fixed, um, if it's worthy of getting fixed to protect it. The um, so what's kind of interesting of this is on 276 you've got the gray shaded text on the left side of the page where Jack he went to